Good morning and welcome once again to Constitutionalist Speaking, right here on the Richard B. Morning Show. We do it every Tuesday morning from 8:05, and we have some really interesting topics which has our listeners all glued to the radio. This morning we're looking at liability for the acts of state agents, and we're going to be looking particularly at what has now gone viral in that incident where a policeman was seen demolishing, really, the electronic equipment belonging to a sound system operator. It has been discussed in several quarters across the island and around the world, for that matter. And this morning we'll get a chance to dissect it from the perspective of the law. And joining us is well-known and learned gentleman, my very good friend, and he's on with us with all the information that we need. He's the Deputy Public Defender, and is none other than Mr. Herbert McKenzie, who's on with us right now. Good morning, Mr. Mack, and welcome. How are you today?
Good morning, sir. Thank you very much. I'm fine. I hope the same for you, too. All right.
It's good to have you. Good to have you once again, Mr. Mack.
Always my pleasure.
Yes.
Before we delve into it, let me just use a minute or two to wrap up where we left off last week.
Okay.
When we were talking about the increase in penalties for the offense of murder.
Mm-hmm.
And I might cut us off at the third piece of law that was passed in mid-July.
Mm-hmm.
The Offences Against the Persons Act, the amendment to it. What it did, or what it does, because it doesn't know, is that previously to the amendment, the non-capital sentence for a person in capital murder was a minimum of 5 years. Now, under the new law, it's now 30 years. Mm. And if the victim is under 18 years, the court can add another 5 years to that. No, 30 years. Mm-hmm. And let me explain. You might say, what you mean by non-capital sentence under capital murder? I started last week. I don't know if I managed to finish it, but there are instances in which more than one persons are involved in capital murder. Now, under the law, the person or persons who did not use force upon the deceit could be liable for non-capital murder, while the person, the group who applied the force would be guilty of a capital murder. Now, for that non-capital participant, is the one who is now liable for the minimum of 30 years. Previously, it was 15 years. Oh. And like I said, if the victim is under 18 years, the court can put another 5 years on top of him. Mm-hmm. Now, there's another category where capital murder, where the defendant or the accuser or the convict gets a death penalty. But when it goes to the Privy Council commutes the death penalty to life and send it back to the local court of appeal for the sentence to be passed. In that case, the minimum period before the person becomes eligible for parole, when the court of appeal passes the sentence, the matter being remitted, is 45 years. It was previously 15 years, mm-hmm. It's now 45 years. So the Offense Against the Person Act is just part of the trilogy of laws that were passed to actually coordinate and put into one package and make consistent the increase in penalty for these offenses. And like I said last week, it's all part and parcel of the package of making crime or creating a deterrence to crime.
Yes.
Generally. How that will work is yet to be seen. Mm-hmm. Anyway, known to liability of the state. And
yes.
You talk about that. But, I saw one recently in which some police officers were actually accosting a man who was genuinely, from the video, resisting arrest. And when we say from the video, we're talking about the clip that we see. We don't know what went on before we saw the clip, yes, and what went on after. So we are restricting our comments to that. And this last one, which I saw, in fact, I saw it yesterday, the man clearly he was resisting arrest. He didn't want to come out of the car. But eventually, they dragged him out, or he came out, and they gave him a good hiding with the button. From the clip, it seems like the button even broke on him. But the point I make, though, is after they subdued him, because I was really resisting physically, and you can see a fairly robust guy.
Yes.
After they subdued him, they continued to beat the guy with the button, beat him badly. But back to our core problem, because what I'm about to say may very well apply to that part too. Now, when this agents of the state, and for this particular reason, this particular occasion, we are concentrating on the police, but the principle generally apply to all the agents of the state, the soldiers, the prison warders, the firemen, and all the other entities who act on behalf of the state, and in particular those who have coercive powers. Now, when they act that way, who has liability? The state has liability, where there are some conditions attached and some other factors that come into play. In law, it is referred to as the vicarious liability. And the vicarious is not a technical term for it. Vicarious means acting or done for another or on behalf of another. That is simple. Now, vicarious liability occurs in a situation where the consequences of the conduct, and by conduct I mean the act or the omission of a person, let's call that person A, whereby his conduct is attributed to another person called B due to a legal or special relationship between those two persons, A and B. It arises primarily with the consequences of A's conduct are detrimental or unfavorable to a third party. Now, the relationship in most cases of this vicarious liability concept usually arises where there's a contract between two parties. Of course, it can arise in other relationships as well. So, for example, in a parent or child relationship, the parent, depending on what the child does, could be held to the vicariously liable for the conduct of the child. Teacher-student relationship, the same thing. Or situations where, say, one of the party exercise what I would call legally coercive control over another. So you might have a children's home or a home for the elderly, where elderly persons are kept. The home itself or the management of the home may be vicariously liable for the conduct of that child or that elderly person, depending on what the conduct of the person or the child is. Similarly, in a case where you have like a prison warder and the inmate, inmate is in the control of the warder, then the warder will be vicariously liable for the conduct of the inmate. This thing of vicarious liability really operationalized itself in the medieval times. And in those times, the master was held to be responsible for all the wrongs of the servants. Over the centuries, with advancement in time, development in industry and commerce, the concept of vicarious liability has evolved into one based primarily upon employer-employee relationship. The thinking in modern times is that modern labor and employment relationship now is that the employer controls the employee in the performance of the job. Now, let me point out a distinction here between that and in a case where a person is contracted for service. And I digress slightly, but you remember the furor that went on a couple of years ago, and it's still going on, whether or not security guard were employees or were independent contractors.
Yes, I remember, yes.
I didn't thought that it's something I'm making. So in a case where a person is contracted for service, is a contractor, the situation is slightly different. The vicarious liability lies in a different direction. Let me give you an example. Say a man called D contracts a man called E to build a shed for him. And in the course of building the shed, E's top carpenter, Mr. Hammer, falls off the roof and injures himself, the roof of the shed. Then D cannot be liable to the carpenter because E was the person who was contracted. So there's nothing between D and the carpenter. So the carpenter will have to look towards E insofar as liability for his injuries is concerned. Now, it is to be noted all that I'm saying that the conduct of the employee for vicarious liability to arise must be in the course of the employment. If the employee goes way out of the scope, totally nothing related to the employment, then the employer can be found not to be vicariously liable, and the employee himself personally liable for the conduct, whether the conduct was detrimental or harmful to anybody else by way of a positive act or by way of omission. Now, that being said, that is the
Principle.
commonest principle of escape that the employers usually adopt when they are visited with a vicarious liability situation caused by the conduct of their employees. Now, police officers are agents of the state, and that can be disputed. Their employer is a government. Hence, it is a government which would be vicariously liable for their acts or omissions committed in the course of the employment. That is in the course of policing. And as we know, that includes maintaining law and order, keeping the peace, and all the other things that goes with policing. If in the course, say, of police officer patrolling the hot, volatile area, a police officer shoots a man, innocent bystander or passerby by mistake, then the government would be liable. The police was acting in the course of his duties, shooting at gunmen or shooting at people who were shooting back or shooting at him. That's one example. At the other end of the scale, if you wish, if that same policeman or member of his patrol, in the course of their duty, stop a citizen going about his or her business and then robs the person, then the government can escape vicarious liability by saying that no, that police officer way outside the scope of his job. In fact, on the very facts of the case, he was doing exactly the opposite of what he was supposed to do. He was supposed to uphold law and order, and then he breached law and order. He committed a criminal offense himself. And in fact, in a case like that, that particular police officer would be visited by the criminal law. But those two examples are the extreme ends of the scale, and things are not quite always like that and a clear cut like that. Now, the one with the policeman who we saw doing the demolition job
On the sound system equipment, yes.
Yeah, that one would fall somewhere in the middle. So in a case like that, the sound system equipment or the sound operator will be seeking compensation, whether or not he does it in court, but this is how it goes. Now, he will be saying that the police was acting in the course of the duty, in the course of policing, because they came there. And, I mean, the police might say, yes, because I want to run and leave the sound system empty and abandon the thing. Fine. Now, the government will seek to escape liability. And I can imagine this is putting on a lawyer cap now. And three bases. One, it did not happen. All we're seeing is AI, artificial intelligence generated image. Two, the person who kicked over equipment is not a police officer. Or three, is somebody in uniform impersonating police. Or three, the police was not acting in the course of the employment. Now, applying our common sense, we can see that the first two must be out.
Yes.
You and I, we know tech guru, but we can see that's not AI. We know that as a policeman. You see me the proper police uniform, and again, this police uniform now have some technical thing built into it that I can tell whether or not it's real or some tailor-made elsewhere.
And he was surrounded by his colleagues as well.
Precisely so. Now, should the government advance the third one, that the police are acting in the course of his employment, was not acting in the course of his employment, then what that would amount to throwing up that policeman under the bus. The way the lawyers normally phrase it is saying that police that was acting on a frolic of his own. That phrase, nice phrase used by lawyers who seek to deflect any claim or assertion of vicarious liability against their client. So, in other words, if the government advance the third one, they would be saying the police were acting on a frolic of its own and not vicariously liable. You'll have to go to the policeman. But in a case like that, the policeman will seek to rescue himself by saying that, no, I was in the course of my duty. And I could imagine him saying, I'm responding to reports of noise breaches under the Noise Abatement Act, and I've been there 2 times, turned off the set, and then the 3rd time they turned it back. So I'm acting in the course of my duty. And in the sense, the policeman will have to say that, because if the government throw him under the bus, all the damages and the compensation award will be awarded against him personally from his personal pocket, and not you and I saying that.
Oh, that's how it works.
What you'll have, yes. So the police, but lawyers, these lawyers are clever. In these civil suits, when you're suing the government under the law, we have a law they call the Crown Proceedings Act. You have to name the Attorney General, because we know the Attorney General is the government's principal legal advisor.
Yes.
In common parlance, the Attorney General is the government's lawyer. So under that law, the Crown Proceedings Act, you have to name the Attorney General as a defendant. What the lawyers normally do is name the individual policeman or policeman too, just in case the government succeeds on escaping the vicarious liability, then it falls back on the individual police or police officers. But like I said, the police officer wants to rescue himself. In a case like that, what you will have is a 2 defendant running what they call a cutthroat defense. In either way, the sound system operator must prevail. Because if it's not the government, it must be the police officer. You all mash up my sound system.
Yes.
And if it's not the police officer personal liability, it must be the government.
Yes.
Either way, that will prevail. I can get another 2 minutes. I see we're on the turn of the clock.
Yes. Go ahead.
I'll give you a practical example. A Jamaican case that went to the Privy Council is called Bernard versus Attorney General. And let me give you the fact quickly. Similar to what we saw in that video. A gentleman by the name of Mr. Clinton Bernard, he was a lithographic printer. At about 9 p.m. on the 11th of February 1990, he went to the central sorting office in Kingston to use the public telephone call box. In those days, for people like you and I who are over 40, realize we never have cell phone at the time. Telephone call boxes were the other day, and people line up to get it to use to make their call.
Yes.
You drop your coins in, and you make your call. It's one of those cases. When Mr. Bernard went to the call box, there were about 15 persons ahead of him in the line, so he waited his turn. He waited patiently. When he eventually got to the front of the line and went to the phone booth, out of the blues, a man rushed into the phone booth, grabbed the phone and shouted, "Police!" and said, "I want to use the phone." The man was a plainclothes man in plain clothes. So Mr. Bernard protested and said, "No, man, this is not how it works. If we were in a bank, you'd have to join the line, stay at the back of the line like anybody else." This man in plain clothes said, "Why am I not joining the line? No, give me the phone." Mr. Bernard held his phone and said, "No, wait." What he did, slap Mr. Bernard in the hand, push the man, shoot the man, and pull a gun from under his shirt and shoot Mr. Bernard.
What?
Yeah, look, it's a real case now. Luckily, Mr. Bernard didn't die. He fell backwards and lost consciousness. When he woke up, he found himself in KPA surrounded by uniformed policemen, and he was handcuffed to the bed. As it turns out, the man who had shot him was a police special corporal named Morgan. Special corporal is when remember when they had the blue seam and red seam difference?
Yes.
Island Special Council. So special corporal Morgan had shot him. What Morgan did was to arrest him and charge him for assaulting police officer.
Wow.
The facts sound eerily familiar with what we see goes on nowadays 30 odd years after. Mr. Bernard spent nearly a month in hospital in pain, unable to walk or move. In fact, the injury was such that he couldn't continue his job as a lithographic printer.
So
they charge him.
At the end of the day, he was not compensated.
1 second, I'll tell you. He, at the end of the day, he was. But let me tell you what the case quickly went. First of all, the criminal charge that the police put on him was dismissed in court, and finally sued the government and the police. At the Supreme Court, the judge at the time was Ms. Zelia McCullough, who eventually became Chief Justice, found in favor for him. And Ms. McCullough laid great score on 2 main points. That in demanding the phone, Morgan said, "Police." That following the incident, Morgan charged Mr. Bernard for assaulting a police officer. Upon this and other evidence, plus remember it was a police gun that he used, the court found for Mr. Morgan and awarded him some good substantial damages. The Attorney General said no. Mr. Morgan wasn't acting in course of police officer, and the Attorney General appealed to the Court of Appeal. The Court of Appeal reversed Ms. McCullough's Supreme Court judgment set it aside. And Mr. Bernard was left empty-handed. They're saying that the policeman, agreeing the Attorney General's submission, was not acting in the course of duty, and the Supreme Court, Ms. McCullough, was wrong. So Mr. Bernard went to the Privy Council. From the Privy Council, allowed the appeal set aside the Court of Appeal judgment and quash that decision and restore Ms. McCullough's decision, and said that at the time, on that evidence, Ms. McCullough was right. Morgan was acting in the course of as a police officer, and his sole purpose was to exercise his authority as a police officer, and the shooting was there unlawful and done in the course or furtherance of his doubt. Quickly, that was the end of the case. Mr. Bernard was awarded a judgment and was rescued. You see that case called Bernard versus Attorney General?
Yes.
It is now the statement of the law on police vicarious liability. The sound system operated the law for him. If that goes to court, we'll hear that name being called. Clifton Bernard versus Attorney General.
Right.
We call that.
Wow, that time. But the truth is, we really learned a lot today. Vicarious liability was dissected, and the whole matter of liability for the acts of the state agents is what we looked at. Mr. McKenzie, I learned so much. I thank you for your time and the information you shared, and we look forward to our next Constitutionally Speaking program next week, Tuesday. Have a good day.
Thank you very much, sir. Same to you.
All the best.